Hi, I'm Jim Ward of the Middle Country Public Library, and I'd like to welcome you to another episode in our History Bites series. Today we will discuss the landmark Supreme Court case, Brown versus the Board of Education, in which the justices ruled unanimously that racial segregation of children in public schools was unconstitutional. In 1896, the Supreme Court ruled in Plessy v. Ferguson that racially segregated public facilities were legal, so long as the facilities for black people and whites were equal. The ruling constitutionally sanctioned laws barring African Americans from sharing the same buses, schools, and other public facilities as whites, known as Jim Crow laws, and established the separate but equal doctrine that would stand for the next six decades. But by the early 1950s, the National Association for the Advancement of Colored People, the NAACP, was working hard to challenge segregation laws in public schools and had filed lawsuits on behalf of plaintiffs in states such as South Carolina, Virginia, and Delaware. In the case that would become most famous, a plaintiff named Oliver Brown filed a class action suit against the Board of Education of Topeka, Kansas in 1951 after his daughter, Linda Brown, was denied entrance to Topeka's all-white elementary schools. In his lawsuit, Brown claimed that schools for black children were not equal to the white schools and that segregation violated the so-called Equal Protection Clause of the 14th Amendment, which holds that no state can deny to any person within its jurisdiction the equal protection of the laws. In October 1952, the court consolidated Brown with three other class action school segregation lawsuits filed by the NAACP: Briggs v. Elliott in South Carolina, Davis v. County School Board of Prince Edward County in Virginia, and Gephardt v. Belton in Delaware. There was also a fifth case that was filed independently in the District of Columbia, Bowling v. Sharp. As with Brown, U.S. district courts had decided against the plaintiffs in Briggs and Davis, ruling on the basis of Plessy that they had not been deprived of equal protection because the schools they attended were comparable to the all-white schools or would become so upon the completion of improvements ordered by the district court. In Gephardt, however, the Delaware Supreme Court affirmed a lower court's ruling that the original plaintiff's right to equal protection had been violated because the African American schools were inferior to the white schools in almost all relevant respects. The case went before the U.S. District Court in Kansas, which agreed that public school segregation had a, quote, detrimental effect upon the colored children, end quote, and contributed to a sense of inferiority, but still upheld the separate but equal doctrine. The plaintiffs in Brown, Briggs, and Davis appealed directly to the Supreme Court, while those in Gephardt and Bowling were each granted certiorari, a writ for the re-examination of an action on a lower court. When Brown's case and four other cases related to school segregation first came before the Supreme Court in 1952, the court combined them into a single case under the name Brown v. Board of Education of Topeka. Thurgood Marshall, the head of the NAACP Legal Defense and Educational Fund, served as chief attorney for the plaintiffs. 13 years later, President Lyndon B. Johnson would appoint Marshall as the first black Supreme Court justice. At first, the justices were divided on how to rule on school segregation, with Chief Justice Fred M. Vinson holding the opinion that the Plessy verdict should stand. But in September 1953, before Brown v. Board of Education was to be heard, Vinson died, and President Dwight D. Eisenhower replaced him with Earl Warren, then governor of California. Writing for the court, Chief Justice Earl Warren argued that the question of whether racially segregated public schools were inherently unequal, and thus beyond the scope of the separate but equal doctrine, could be answered only by considering, quote, the effect of segregation itself on public education, end quote. Displaying considerable political skill and determination, the new Chief Justice succeeded in engineering a unanimous verdict against school segregation the following year. Warren held that such inequalities existed between the schools in the case before him, despite their equality with respect to tangible factors such as buildings and curricula. Specifically, he agreed with the finding of the Kansas District Court that the policy of forcing African American children to attend separate schools solely because of their race created in them a feeling of inferiority that undermined their motivation to learn and deprived them of educational opportunities they would enjoy in racially integrated schools. This finding, he noted, was amply supported by contemporary psychological research. As a result, the court ruled that the plaintiffs were being, quote, deprived of the equal protection of the laws guaranteed by the 14th Amendment. He concluded that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. In its verdict, the Supreme Court did not specify how exactly schools should be integrated, but asked for further arguments about it. In May 1955, the court issued a second opinion in the case known as Brown v. Board of Education II, which remanded future desegregation cases to lower federal courts and directed district courts and school boards to proceed with desegregation with all deliberate speed. Though well-intentioned, the court's actions effectively opened the door to local judicial and political evasion of desegregation. While Kansas and some other states acted in accordance with the verdict, many school and local officials in the South defied it. In one major example, Governor Orville Faubus of Arkansas called out the state National Guard to prevent black students from attending high school in Little Rock in 1957. After a tense standoff, President Eisenhower deployed federal troops, and 9 students, known as the Little Rock Nine, were able to enter Central High School under armed guard. Arkansas's governor responded by closing all of Little Rock's public high schools in 1958-59. Other southern cities followed suit, often implementing school choice programs that subsidized white students' attendance at private segregated academies, which were not covered by the Brown ruling. As a result, many southern schools remained almost completely segregated until the late 1960s. Passage of the Civil Rights Act of 1964, backed by enforcement by the Justice Department, began the process of desegregation in earnest. This landmark piece of civil rights legislation was followed by the Voting Rights Act of 1965 and the Fair Housing Act of 1968. In 1976, the Supreme Court issued another landmark decision in Runyon v. McCrary, ruling that even private non-sectarian schools that denied admission to students on the basis of race violated federal civil rights laws. By overturning the separate but equal doctrine, the court's decision in Brown v. Board of Education had set the legal precedent that would be used to overturn laws enforcing segregation in other public facilities. But despite its undoubted impact, the historic verdict fell short of achieving its primary mission of integrating the nation's public schools. However, the success of Brown galvanized civil rights activists and increased efforts to end institutionalized racism throughout American society. Thank you for joining us for today's episode. If you enjoyed it, click like, and if you watched on YouTube, hit subscribe. Thanks so much, and we'll see you all next time.